at the age of 72. He never saw the finished Supreme Court building. By 1934, the most important question about the Supreme Court was how the justices would respond to the New Deal, President Franklin Roosevelt's drastic remedies for the Great Depression. The President and the Democratic Congress passed laws designed to provide Depression relief, but a conservative Supreme Court rejected many of the measures. In 1937, Roosevelt proposed a court reorganization bill that would allow him to appoint more justices to the Supreme Court, men that would be much more sympathetic to his New Deal policies. Roosevelt wanted to increase the number of justices from 9 to as many as 15. The Constitution does not specify how many justices should sit on the Supreme Court, so the proposal was legal, although not very popular with members of Congress. They viewed Roosevelt's court-packing plan as detrimental to the court's time-honored practice of judicial review. The President decided to abandon the court-packing bill due to lack of congressional support, and Chief Justice Charles Evans Hughes' furious lobbying against the bill. It was his first major defeat in Congress. But all was not lost for Roosevelt. Between 1937 and 1943, various deaths and resignations enabled him to make 9 Supreme Court appointments. The Roosevelt Court, as many called it, took a broad view of federal powers. In 1941, in Chief Justice Hughes's last major decision, child labor practices were finally dealt a decisive blow. In the case of United States versus Darby Lumber Company, the court unanimously sustained the Fair Labor Standards Act, which outlawed child labor and also regulated wages and hours of workers making products shipped in interstate commerce. In 1946, President Harry Truman appointed Secretary of the Treasury Fred M. Vinson as Chief Justice of the Supreme Court. The Vinson Court is best remembered for a decision that went against the government and that permanently set limits on presidential power. In 1952, at the height of the Korean conflict, the nation's steel mills were about to be shut down by a major strike. Because steel production was vital to the war effort, Truman invoked his war powers under the Constitution and seized the steel mills. The Supreme Court asserted its authority in the case of Youngstown Sheet and Tube versus Sawyer and stopped the president's seizure of the steel mills, declaring that the Constitution did not allow him to seize private property. Truman unwillingly abided by the court's decision. Chief Justice Vinson died suddenly in the summer of 1953, just as the court was in the middle of hearing arguments on a number of civil rights cases brought by African Americans challenging state laws segregating public school systems. President Dwight D. Eisenhower appointed California Governor Earl Warren as the new Chief Justice, and he was appointed because of his mainly conservative views. But Warren surprised many of his detractors by becoming a guardian of individual rights and racial equality. Chief Justice Warren used the case of Brown versus Board of Education as the catalyst to end school segregation. In 1951, a railroad worker named Oliver Brown sued the city of Topeka, Kansas. His daughter was prevented from attending an all-white school in their neighborhood. Brown was represented in the Supreme Court by lawyer Thurgood Marshall. On May 17, 1954, the Supreme Court announced its unanimous decision in Brown versus Board of Education. It was the first of 2 landmark decisions. The ruling, called Brown 1, held that the separation of blacks and whites is inherently unequal. The 60-year-old case of Plessy versus Ferguson, which said that separate treatment of blacks and whites did not violate the 14th Amendment, was struck down. A year later, Brown 2 was announced. The justices decided that local federal courts would supervise local school board efforts to desegregate, and that desegregation must be accomplished with all deliberate speed. In 1967, Thurgood Marshall, the lawyer who so ardently argued the Brown case, became the first black justice of the U.S. Supreme Court. He was appointed by Lyndon Johnson. Another landmark decision of the Warren Court dealt with criminal rights. In the case of Miranda versus Arizona, the court ruled that suspects in police custody must be informed of their constitutional rights to remain silent, to have an attorney appointed to them, and be present during questioning, and they must be told that anything they might say can and will be used against them in a court of law. This ruling is known as the Miranda warning. It must always be read to suspects before questioning them. Chief Justice Warren died in 1974. He was mourned by those who saw him as a true social reformer and crusader for the rights of the underprivileged. In 1969, President Richard Nixon appointed Warren E. Burger to the position of Chief Justice. The court under Burger was notably more conservative than the Warren Court, but there was no wholesale reversal of decisions. The court continued its activist stance. Between 1969 and 1976, the court nullified more acts of Congress on First Amendment and equal protection grounds than all of its predecessors combined. In 1973, the issue before the court was whether the Constitution guaranteed a right to privacy that extends to a woman's decision to obtain an abortion. In the case of Roe v. Wade, Justice Harry Blackmun wrote the majority opinion in which he stated that although the Constitution does not explicitly mention a right to privacy, the court had previously found such a right to exist, and that right was broad enough to cover a woman's right to make decisions regarding her own body. The Supreme Court's decision on Roe v. Wade deeply divided the nation. In June of 1973, Chief Justice Burger produced the first legal definition of obscenity to command a court majority. The case was Miller versus California. The majority ruling was a close 5-4 vote. Instead of setting a national guideline for what is and what is not considered obscene, the landmark decision allowed communities to develop their own locally based standards. This allowed for more widespread local obscenity prosecutions. The Burger Court held that states did not violate the First Amendment when they enacted laws regulating obscene material. In 1974, the court exercised its power over the president once again. During the Watergate scandal that plagued Richard Nixon's second term as president, he refused to turn over taped recordings of his staff meetings to investigators.
I was aware of listening devices.
I see no redeeming features in Watergate.
What did the president know, and when did he know it?
Because people have got to know whether or not their president's a crook. Well, I'm not a crook.
Nixon cited executive privilege to prevent the disclosure of the tapes. But in the case of United States versus Nixon, the Supreme Court decided against the president and forced him to turn over the tapes to the investigators.
I shall resign the presidency effective at noon tomorrow.
In August of 1974, Richard Nixon resigned rather than face impeachment and removal from office. The Supreme Court asserted its belief that no one, not even the President of the United States, was above the law. Another landmark during the Burger years was the appointment of Sandra Day O'Connor to the bench in 1981. She became the first woman ever to hold the position of Supreme Court Justice. Chief Justice Burger resigned from the court in 1986. He wanted to devote his time to head the National Commission appointed to commemorate the bicentennial of the United States Constitution. President Ronald Reagan appointed Associate Justice William H. Rehnquist to become the nation's 16th Chief Justice of the Supreme Court. The Rehnquist Court, which started out looking like the most conservative court since Taft was Chief Justice, slowly moved closer to the middle of the ideological center. President George Bush appointed Clarence Thomas to the bench in 1991, becoming only the second African American appointed to the Supreme Court and also the youngest. In 1993, President Bill Clinton appointed Ruth Bader Ginsburg, making her the second woman to sit on the Supreme Court. The court looks as diversified today as it has ever been. For both civil and criminal cases, the Supreme Court hears arguments during its regular session called the October term. It begins on the first Monday of October and usually ends in midsummer of the following year. The court may hold special sessions whenever they deem it necessary. The Supreme Court chooses which cases it will hear In nearly every instance, an individual or organization will petition the court to hear his or her case. The justices meet in their private conference room to vote on which cases they will hear. If at least 4 justices want to hear a case, the petition is granted. Of about 2,000 to 3,000 cases the court is asked to review each year, only about 160 to 200 are granted. When a case reaches the Supreme Court, lawyers for both sides are each allowed only 30 minutes to present their argument. The court schedules 4 arguments a day. The Supreme Court tape records and transcribes every oral argument it hears. After they hear arguments for several cases, the court justices discuss and decide them in conference. All conferences are held in complete secrecy. No one other than the 9 justices is permitted to enter the conference chamber. The Chief Justice calls the first case to be decided and speaks first on the matter. The other justices speak in order of their seniority on the court. After the discussion, the justices vote in reverse order on the case, beginning with the most junior justice and ending with the Chief Justice. To decide a case, the court must have a majority vote. 5 votes if all 9 of the justices are involved. After a majority vote has been reached, they write an opinion on the case, a document that announces the decision and the reasons behind it. On the days that the court announces its decisions, the justices meet the press and public in the Supreme Court chamber, and the decisions are read out one by one. Not only is the majority opinion read, but the dissenting opinion is read as well. The Supreme Court is considered by many to be the guardian of the Constitution, but Alexander Hamilton claimed the Supreme Court was the weakest department of power. The Supreme Court has the power to decide if the laws passed by Congress are constitutional, and if the actions of the President are done pursuant to the Constitution. The Supreme Court has the power to keep in check the legislative and executive branches of the federal government. It is the major force that shapes the development of law and public policy in the United States of America.